Hello class, a pleasant day to you all. Before we begin our discussion, let us start our day with a prayer. Psalm 23. The Lord is my shepherd, I shall not want. He makes me lie down in green pastures. He leads me beside still waters. He restores my soul. He leads me in paths of righteousness for His name's sake. Even though I walk through the valley of the shadow of death, I will fear no evil, for you are with me. Your rod and your staff, they comfort me. You prepare a table before me in the presence of my enemies. You anoint my head with oil. My cup overflows. Surely, goodness and mercy shall follow me all the days of my life, and I shall dwell in the house of the Lord forever. Amen and amen. Okay. So, greetings class. Our discussion or topic for today is all about the rules on evidence. Okay. So again, I have uploaded the notes in the files already, and I would like to state again that this reviewer I am using, I got it in the internet, so I don't know the author, but I have reviewed it, and it summarizes the rules on evidence. So I would like to state for the record that for intellectual property purposes, this reviewer is not mine, okay? So I don't know who is the owner of this reviewer, but I'm using this just to show the overview of the rules on evidence, okay? So without further ado, let us begin. So the rules on evidence class is a provision which is part of the rules of court. So right now there are amendments, okay, in the rules of court. However, our discussion today is just the basic. We will just cover the overview, okay. We will just make a rundown of the basic concepts of evidence. Okay, so let us begin. What is evidence? Under the rules, evidence is the means sanctioned by the rules of court of ascertaining in a judicial proceeding the truth respecting a matter of fact. Okay, so that is under section 1 of Rule 128 of the Rules of Court. So what does that mean? So, evidence class, there are 4 components or elements. First, it is a means of ascertainment. Okay? So, when you say ascertainment, you review, okay? You ascertain. So, it includes not only the procedure or manner of ascertainment, but also the evidentiary fact from which the truth respecting a matter of fact may be ascertained. Okay? So, second element is it is sanctioned by the rules. Okay? So, when you say sanctioned by the rules, it means that it is not excluded by the rules of court. Okay? It is included in the rules of court. Next element is that it is produced or found, or it is, how do you call this, presented in a judicial proceeding. Okay, so that's the another element. It is presented in the judicial proceeding, which means it contemplates an action or proceeding filed in a court of law. And then, lastly, the truth respecting a matter of fact. So, what does that mean? So, it refers to an issue of fact and is both substantive, okay, which determines the facts needed to be established, and procedural. So it governs the manner of proving said facts, okay? So why is evidence required in a judicial proceeding? So under the law, it is required because of the presumption that the court is not aware of the veracity or truthfulness, okay, of the facts involved in a case. It is therefore incumbent upon the parties to prove a fact in issue through the presentation of admissible evidence or evidence which are sanctioned in the rules of court. Okay? So let's go to its applicability. So the rules of evidence, being part of the rules of court, apply only to judicial proceedings. Okay? So it is a well-settled procedural principle that the rules of court shall not apply to election cases, land registration, cadastral, naturalization, insolvency proceeding, and other cases who has its own internal rules, okay? But except by analogy or in suppletory character and whenever practical and convenient. So even though there are internal rules in a proceeding like election cases, land registration, however, the rules of court has a suppletory character, okay? So what does it mean to have a suppletory character? So it supplements, okay, the procedure of other cases, okay? So it is supplementary. In case that there are gray areas or provisions which are absent, then the rules of court can be applied because it has a suppletory character. However, the rules on electronic evidence apply to all civil actions and proceedings as well as the quasi-judicial and administrative cases. Okay? So, let's go to scope. The rules of evidence shall be the same in all courts and in all trials and hearings except as otherwise provided by law or the rules of court. Okay? So, the rules of evidence class shall be the same in all courts. So, it means it is uniform and in all trials and hearings. Okay? However, it does not apply to election cases, land registration, cadastral, naturalization, and insolvency proceeding as stated above. So, if the case has its own internal rule, then that rule will apply. Okay? So, if, for example, that rule or procedure has a gray area, okay, or has provisions that does not touch a certain procedure, so the rules of court will become will be applied suppletorily. Okay, examples of instances where rules of evidence do not apply to judicial proceedings. First is the rules on summary procedure in civil actions, okay? It has its own internal rules, okay, that must be followed. Next, in the rules of summary procedure in criminal cases, where the witnesses submit their affidavits and counter-affidavits subject only to cross-examination, okay? So it has its own rule. Next, agrarian cases. And the next, rules regarding the testimony of witnesses from examination. Example, in cases under the MTC where the parties merely submit their position papers and their witnesses, affidavits, and counter-affidavits. Okay, so the rules on evidence will not apply in these instances. However, it has a suppletory character. So whenever there is gray areas, then as a lawyer or as a judge, you can always refer to the rules of court. Okay? The rules of evidence are applicable to both civil and criminal cases because the law does not distinguish. However, it accepts of exception. So what are these exceptions? So when the law specifically provides the procedure in receiving evidence, so if there is a specific provision supplied by the law itself, then it is an exception. Okay? So the purpose of evidence is to ascertain the truth. However, the truth is not really the actual truth for the findings of the court, but would depend on the evidence presented, and such is called the legal truth. Okay? So the court will ascertain. Okay? It will weigh the evidence presented until the judge, until all evidence will lead to the legal truth. So evidence is only required when the court needs to resolve a question of fact. Okay? So when there is an issue, so the court must receive evidence in order to weigh those evidence so that a question of fact can be answered. So the case must present an issue of fact. Okay? So in law, there are two kinds of facts. First is the ultimate fact, and then second is the evidentiary facts. So what is an ultimate fact or factum probandum? So it means that principal, determinate, and constitutive facts upon the existence of which the plaintiff's cause of action rests. So does not refer to the details of the probative matter or particulars of evidence by which these material elements are to be established. Proposition to be established, necessarily hypothetical. Okay? So, in the other hand, factum probans or evidentiary facts contemplates that facts which are necessary for the determination of the ultimate facts. Okay? So, premises upon which conclusions of ultimate facts are based and then brought forward as a reality to convince the tribunal that the factum probandum is also real. Okay? So, factum probans as differentiated with regards to factum probandum. So, in factum probans class, these are intermediate facts, okay? Facts which are present, okay? Which are necessary for the determination of the ultimate facts. In the other hand, factum probandum is the ultimate facts that you need to ascertain, okay? So, there are propositions to be established in factum probandum, and sometimes it is hypothetical. However, in factum probans, there is material evidencing of the proposition, and its existence must be immediate or intermediate. Okay? So, distinction between proof and evidence. So, sometimes proof and evidence can be interchanged. However, there are difference. So, proof is not the evidence in itself, okay? So, there is proof only because of evidence. It is merely the probative effect of evidence and is the conviction or persuasion of the mind resulting from a consideration of the evidence. So proof is lighter than the term evidence. Evidence is the medium or means by which a fact is proved or disproved. Okay? So, proof is the effect of evidence. It must be remembered that the bare allegation unsubstantiated by evidence are not equivalent to proof. Okay? So in the eyes of the law class, it is the evidence which is necessary in order to prove your claim. Okay? So if you present facts, if you present factum probans, okay, intermediate facts in order to come to factum probandum or the ultimate facts, then the ultimate facts becomes your evidence, which will be used in the course of the trial. Okay? So, requisites for the admissibility of evidence. Under Section 3 of Rule 128, evidence is admissible when it is relevant to the issue and is not excluded by law or these rules. Okay? So, earlier, in the definition of evidence, okay, so it is sanctioned by the rules. So, meaning, it is not excluded by the rules. So, that is the proof or the evidence must be relevant and is sanctioned. Okay? So, the requirements of the law in order for evidence to be admissible is that it is relevant to the issue. Okay? And it is not excluded by the rules. So it means that it is competent in nature. Okay? So two axioms of admissibility. First is relevancy, and then second is competency. So these are the two requirements in order for the evidence to be admitted in court. So what does it means to be relevant? Okay, so none but facts having rational probative value are admissible. So when you say relevancy, so it is relevant to the issue at hand. Okay, so the facts, the probative value of the facts must be connected with the issue. Okay. Next is competency. So all facts having rational probative value are admissible unless some specific rule forbids their admission. So in the competency part, you need to check with the rules of court. Okay? Because when you say competency, it means that it is sanctioned by the rules of court. So to be admissible, the evidence must be both relevant and competent. Okay? So under Section 4 of Rule 128, evidence to be relevant must have a relation to the fact in issue as to induce belief in its existence or non-existence. It deals with the rational relationship between the evidence and the fact to be proved. So this fact may either be immediate fact, okay? So when you say immediate, factum probans in issue, or the ultimate fact or factum probandum in issue, okay? So example, a car accident. Factum probans or immediate facts is to prove that the defendant is driving way beyond the speed limit. So factum probandum or the ultimate fact in a car accident is whether or not the damage caused to the plaintiff arose out of the defendant's negligent operation of his car. Okay? So these are the nuances of the two. Okay? So there is no precise and universal test of relevancy provided by law. However, the determination of whether particular evidence is relevant rests largely at the discretion of the court, which must be exercised according to the teachings of logic and everyday experience. Okay? Now, let's go to competent evidence. So, if the test of relevancy is logic and common sense, the test of competence is the law or the rules. Okay? because as stated earlier, competent evidence are sanctioned by the rules. They are not excluded by the rules. That is why you need to check what is in the rules. So the question to be asked is whether the evidence is allowed by the law or by the rules. For if allowed, such is competent, and if not, it is incompetent. Okay? So competency when applied to a witness refers to his eligibility to take the stand and to testify. For purposes of trial objections, it is sloppy to object to a testimony or a document as incompetent, for the term is appropriately directed to the witness. Okay? So as for electronic evidence, it is competent and admissible if it complies and is authenticated in the manner prescribed by law. Okay? So there are requirements in order for an evidence to be admitted, or in order for an evidence to be competent. Okay? So take this for example, electronic evidence. So in order to admit electronic evidence, the requirements of authentication, okay, must be complied with, okay, as required by Section 3, Rule 3 of the Rules of Electronic Evidence. Okay? Now, let's go to another concept of law, corroborative evidence. So, what is corroborative evidence? It is additional evidence of a different kind and character tending to prove the same point. So, when you say corroborative, it means these are other evidence that will support, okay, a claim. Okay? So, it corroborates. For example, the testimony of witness A is supported by the testimony of witness B. So the term you will use with regards to the testimony of witness B is that his statement is corroborative. Okay? So the statement of witness B is a corroborative evidence because it tends to support another evidence. Next is cumulative evidence. So it is additional evidence of the same kind and character tending to prove the same proposition. Next, irrelevant evidence. Offered piece of evidence has no probative value. So when you say irrelevant, it has no connection to the issue. That's why it has no probative value. Next is inadmissible evidence. So offered evidence is excluded by some rule of evidence. Okay? Next, incompetent evidence. Offered evidence is not qualified under the rules of testimonial evidence. Okay, so when you say incompetent, it is not sanctioned, it is not included on the rules. Okay? Next, immaterial evidence. So the offered evidentiary fact is directed to prove some probandum which is not proper in issue. So the rule of substantive law and of pleading are what determines immateriality. So when you say immaterial evidence, these are evidence which has no causal connection with the case, hence immaterial. Okay? Next concept is conditional admissibility. Okay? So by the way, class, since the rules on evidence is also very broad topic, we will just make a rundown. Okay? That is why I chose this reviewer because it touches different topics of the rules on evidence, and mostly it is using the terms and definition in order to discuss the concept of evidence. Okay? So multiple admissibility. When a fact is offered for one purpose and is admissible insofar as it satisfies all rules applicable to it when offered for that purpose, its failure to satisfy some other rule which would be applicable to it offered for another purpose does not exclude it. Okay, so when you say multiple admissibility, a piece of evidence can be used, okay, as evidence in another issue. Okay, for example, in a case there are many issues, so and you present an evidence, so multiple admissibility implies that this evidence can be used by those issues at hand. Okay, next is curative admissibility. A party has the right to introduce incompetent evidence in his behalf where the court has admitted the same kind of evidence adduced by the adverse party. This is to prevent manifest injustice. So the concept of curative admissibility, so a judge, even though the evidence you presented, he declared it to be competent, but still you need to attach it in the record, okay? Because sometimes judge commit mistake, and what if when you appeal your case, that evidence will be considered, okay? So that's why it is called curative admissibility when you also present incompetent evidence, okay? However, later on during appeal, if it can be considered, then it is coined curative admissibility. Collateral matters. So matters other than the fact in issue and which are offered as a basis merely for inference as to the existence or non-existence of facts in issue. So when you say collateral matters, these are other matters or other issue which is not the main issue or the main matter, however still relevant to the case. Okay? So two axioms of admissibility. So only those facts which have rational probative value are admissible as a general rule. However, there are exceptions. Okay? Next, all facts having rational probative value are admissible unless prohibited by some specific rule. Okay? So, again, the concept of relevancy and competency in admissibility of evidence. Okay? So, instances when proof can be dispensed with. So, when you say the proof can be dispensed with, it means that it does not need to give additional evidence anymore in order to prove that matter. So what are these instances? First is res ipsa loquitur. So this is a Latin term which means the thing speaks for itself. Okay? Next are presumptions. So when you say presumptions, these are presumptions covered under the rules on evidence. So do not worry class, because I also uploaded the codal provisions of the rules on evidence in your files. So for reference, just open it, and then you can see all the presumptions, disputable presumptions under the law. Okay. Next instance is judicial notice. So, for example, the court has already taken judicial notice of a certain fact, then you need not to present additional evidence on that matter. And then lastly, judicial admissions. Okay, when you admit a certain fact within the course of the trial. Okay? So, kinds of presumptions. So, under the rules on evidence, there are conclusive presumptions and disputable presumptions. Okay? So, take note of this class. These presumptions are found in the rules on evidence. Okay, so just open the codal provision for reference. So when you say conclusive, which the law does not allow to be controverted. So it is conclusive. It cannot be controverted or changed. Okay. Next is disputable. So which are satisfactory if uncontradicted. So when you say disputable, it can be challenged. However, if you will not challenge it, it becomes controverted or conclusive. Okay? So, but which may be contradicted and overcome by other evidence. So, in disputable presumptions, you need to present evidence in order to challenge it. Next is judicial notice. Cognizance of certain facts by the court without proof because they are facts which by common experience are of universal knowledge among intelligent persons within a country or community. Okay? So when you say judicial notice, these are public knowledge, okay, which the court takes judicial cognizance or judicial notice. Okay? Next, requisites of judicial notice. So first requisite is that it is a matter of common knowledge or public knowledge. Okay? Second, well and authoritatively settled and not doubted or uncertain. Okay? For example, it is public knowledge that a female is a female. Okay? It is public knowledge that the weather, sometimes it's hot, sometimes it's cold. Okay? So, you don't have to present it, you don't have to present evidence in court in order to prove those public knowledge. Okay? Now, matters that are judicially noticed, okay, mandatory. First is the existence and territorial extent of a state. Okay? So, there is judicial notice of the jurisdictions or sovereignty of each states. Next, forms of governments and symbols of nationality like a flag, okay? The court would take judicial notice, so you don't have to present evidence in order to prove the claims. Next, laws of nations, and then Admiralty, Maritime Courts of the world and their seals, political constitution and history of the Philippines, the law of nature, the measure of time, the geographical divisions and political history of the world, facts which are public knowledge, okay, like what I said earlier, that for example, a woman is a girl. Next, facts which are capable of unquestionable demonstration, and then facts which ought to be known to judges because of their judicial functions, okay. Next is discretionary judicial notice. So these are matters of public knowledge, however capable of unquestionable demonstration, ought to be known to judges because of their judicial functions. So when you say discretionary judicial notice, it depends on the sound discretion of the court whether he admits it or not. Okay? So there's a case here. We will not discuss it because I will be giving cases also. Okay? So that you can appreciate the theories discussed in this topic. I will give you case digest, okay, which I will upload in the files also. Now, let's go to the rules of admissibility. What is an object evidence? So, object or real evidence, that which is addressed directly to the senses of the court without intervention of a witness as by actual sight, hearing, taste, smell, or touch. So, otherwise known as autoptic preference. Okay, so when you say object evidence, these are physical evidence, real evidence, which are subject to the or addressed directly to the senses of the court. Okay? Next, documentary evidence. So documents as evidence consist of any material containing letters, words, and numbers, figures, symbols, or other modes of written expressions offered as proof of their contents. Okay? So documentary, these are letters or documents which tend to prove a certain fact. Okay? So original of a document, the contents of which are subject of the inquiry. So when a document is in two or more copies executed at or about the same time with identical contents, and when an entry is repeated in the regular course of the business. Okay, so as a general rule, class, document, especially affidavit, it must be authenticated in court. Okay, so you present the one who executed that document, and then in order for it to be accepted as evidence, okay, for example, your judicial affidavits, okay, you have to authenticate this in court. Next, exceptions to the rule that only original documents may be admissible. Okay, as a rule, class, you need to, especially when you rest your case and submit the evidence, you need to present the original in court. Okay, you need to submit the original. So when the original has been lost or destroyed, however, there are exceptions, and the following are the exceptions. When the original has been lost or destroyed, when the original is in the custody or control of the party against whom it is offered and the latter fails to produce it, when the original is a public record in the custody of a public officer or is recorded in a public office, and when the original consists of numerous accounts or cannot be examined by the court without great loss of time. Okay, so those voluminous documents. What is best evidence rule? So under the law, only original of the document is admissible. Okay, so that's the reason behind why you submit original documents, because it is the best evidence, okay, as basis in order to arrive to a decision. So merely assures presentation of the original documents and bars non-original documents and etc., but not evidence aliundi or parole evidence. So when you say evidence aliundi or parole evidence, these are evidence that you will introduce, okay, to support your main evidence. So statements, okay, affidavits, and so on and so forth, refers only to the factum probandum but not the interpretation of the document. So when you say factum probandum, it is the ultimate facts. Okay, so original must be presented first before the evidence aliundi may be presented. Okay, next is secondary evidence. So that which shows that better or primary evidence exists as to proof of the fact in question. So when you say secondary evidence, these are collateral evidence which will help you prove your point or your case. Okay, it is that class of evidence which is relevant to the fact in issue. It is being first shown that the primary evidence of the fact is not obtainable. Okay, so you can present secondary evidence if the primary evidence can't be obtained or submitted. So when secondary evidence is admissible, first, original has been lost or destroyed. Okay, so when you cannot present the original because it is already lost or destroyed. Second, prove the existence or execution of the original. Third, prove the cause of the unavailability of the original is not due to the bad faith of the offerer. Okay? So, you must prove that the original is unavailable in order for you to present secondary evidence. So, what are the three kinds of secondary evidence that may be presented in court? First, copy of the writing, and then second, recital of its content in some authentic document. Third, recollection of witnesses in order stated. Okay? So, what is authentic document? It is merely means that the document should be genuine, okay? Authentic, original. It need not be a public document, okay? So, it must be the original, the genuine document, even though it is not a public document. What is parole evidence rule? So, forbids any addition to or contradiction of the terms of a written instrument by testimony purporting to show that at or before the signing of the document, other or different terms are orally agreed upon by the parties. So, when you say parole evidence, these are testimonies, okay, or which you present in court in order to prove a certain fact, okay. Exception to the parole evidence rule. So, it must be alleged in the pleading. First, failure of the written agreement to express the true intent and agreement of the parties. Second, intrinsic ambiguity. Third, validity of the written agreement. And then fourth, existence of other terms agreed to by the parties. Okay, so in order to prohibit the other party to present parole evidence, you must state in your pleading that these exceptions, okay, that there was failure in the written agreement to state the true intention of the parties, or the agreement is ambiguous, or there is question of the validity of the agreement, and there is existence of other terms agreed to by the party which is not on the document presented in court. Okay. By the way, class, the rules on evidence is very technical. So if you have questions because you cannot understand some provision, just message me anytime, okay? Because this is just a crash course, okay? This is just a rundown for your promotion, for your schooling. Because if you really want to be serious with the rules of evidence, you need to study it probably more or less 6 months, okay? Because it is very broad, class, I tell you, and very technical. And then I am only given 4 hours to cover everything. So that is why I'm using a reviewer as an overview for the rules of evidence, okay? So next, let's go to ambiguities. Okay? So there are 2 kinds. First, patent or extrinsic ambiguity. Next is latent or intrinsic ambiguity. So when you say patent, where the instrument on its face is unintelligible, okay, or incomprehensible, cannot understand it. So there is patent ambiguity. When you say latent, or the words of the instrument are clear but their application to the circumstance is doubtful, okay? So when you say latent, it is internal. The ambiguity or question is internal in character. So in its face, the document is valid. However, when you apply it, there is already doubt. Okay? So the rule permits parole evidence to explain an intrinsic ambiguity. Now, rules governing admissibility of parole evidence to explain ambiguity. So, these are just matters of reading class. I will leave this up to you. I have uploaded the notes on the files, the codal provisions, and other notes that will help you understand the rules on evidence. Okay? So, difference between best evidence rule and parole evidence rule. As to document, in the best evidence, all kinds are covered. However, in parole evidence, only agreements, contracts, and wills which are covered. Okay? So, as to what is excluded, in the best evidence, secondary evidence or copies are excluded because what is essential are the original or primary evidence. Okay? However, on parole evidence, any oral written evidence to prove contents prior or contemporaneous with the contract can be presented in court. Okay? So, in best evidence, you need to present the original. Okay? However, if lost or destroyed in the possession of the adverse party or in the possession of a public officer, then you need not to present it. Okay? On the other hand, in parole evidence, if there are ambiguity, you need not to present the original also. Especially the contents of the document does not express the true intention of the parties. Okay? So, just a matter of reading, class. So, there are cases that is discussed here. We will fully discuss the cases later in the case analysis. Okay? So, what are the classes of documents? First is a public document. So, when you say public document, it consists of the written official acts or record of the official acts of the sovereign authority, official bodies and tribunals and public officers, whether of Philippines or of foreign country. Okay? So, one classic example of a public document are those documents which are notarized by a notary public. Okay? For example, I am a lawyer, I am a notary public, and then I notarized a deed of absolute sale. So that deed of absolute sale is a public document. Okay? These documents are evidenced by either official publication thereof or a copy attested by the officer having legal custody of the record or by his deputy. Okay? Matters of reading class. Another public documents acknowledged before a notary public. I have discussed this. Public records. Okay? Next, private, consisting of all other writings. So before any private document offered as authentic is received in evidence, its due execution and authenticity must be proved either by anyone who saw the document executed or written, or evidence of the genuineness of the signature or handwriting of the maker. So any other private document need only be identified as that which it is claimed to be. So if the document class which is presented in court is private, then you need to authenticate such document. Okay? So it must be the one who execute it must be presented in court in order to authenticate the same. Okay? So a judicial record may be impeached by evidence of want of jurisdiction in the court or judicial officer. Next, collusion between the parties, or if there is fraud. Okay? So you can impeach or challenge evidence presented in court through the following, okay? Next, documents that do not need to be authenticated. So first, public documents, notarized documents, or ancient documents. So these are documents which are at least more than 30 years old. Okay. So ancient document rule, where a private document is more than 30 years old, okay, is produced from a custody in which it would naturally be found if genuine and is unblemished by any alterations or circumstances of suspicion. So no other evidence of its authenticity need be given. So when you say you authenticate it in court, it means you identify it in court, in open court, or during the judicial proceedings. Okay? So in what instances must alteration in documents must be accounted for by the producing party? So the document being produced as genuine has been altered. The alteration appears to have been done after the execution of the document. The alteration appears to have been in a part material to the question in dispute. Okay, so if there are alterations in a document, that is why the more you need to authenticate it when it is presented in court. Okay. So, the producing party must show that the alteration was. So, when you say authenticate, you need to prove it in court. So, you present the person. So, the person must prove that the alteration is made by another, made without his concurrence, made with the consent of the parties affected by it. Okay, otherwise properly or innocently made, or such that it did not change the meaning or language of the instrument. Okay, classic example. I notarized a deed of absolute sale. However, the names were mistakenly made, so I erased it and then I signed it. So when there is an issue, so I will be presented in court, okay, as a lawyer, as the notary public, and then I will authenticate it. So I will identify it, especially the erasure, that indeed I made that erasure because the names were erroneously written. Okay? Next is interpretation of documents, just a matter of reading, class. Okay? I will leave this up to you. Let's go to testimonial evidence. So as a general rule, the following are not grounds for disqualification. Okay? Religious belief, political belief, interest in the outcome of the case, and conviction of a crime. However, it accepts of exceptions, so when provided for by law. So, grounds for disqualification enumerated in the rules on evidence. So, disqualification by reason of, first, mental incapacity. Okay? The person is not of sound mind. Okay? So, when he is crazy or imbecile, then he do not have the mental faculty to be a witness. Okay? So, you can challenge that. You can object. And you can move that the witness be disqualified by reason of mental incapacity, another immaturity, another by reason of marriage, another by death or insanity of the adverse party, and then privilege communication. Okay? So let us distinguish between the marital disqualification rule and the privileged marital communication rule. So, extent of prohibition under marital disqualification, it is total, okay? All testimony, whether adverse or regardless of source, okay? So, when you say marital disqualifications, you cannot present the spouse of the other party in court because, as you can see, the prohibition is total, okay? However, under privileged marital disqualification, only confidential communication are barred to be presented in court. Okay? Next, should either spouse be a party in marital disqualification? Yes. They must be a party to a case in order for the lawyer to object on the ground of marital disqualification. However, in privileged marital disqualification, it is not necessary that the other spouse is a party. Okay? Next, marriage subsisting at the time of testimony. Yes, okay. Under marital disqualification, there must be a subsisting marriage. Okay? However, in privileged marital disqualification, then it is not necessary whether there is an active marriage. So in marital disqualification class, if both of you are already annulled, then you cannot make this as a ground of your objection or disqualification. Okay? So who can invoke? In marital disqualification, the affected spouse. In privileged marital disqualification, the other spouse. Okay? Next, operability of the rule. So in marital disqualification, it ceases upon the death of either spouse or termination of marriage. Okay, like annulment, divorce. Okay. So in the Philippines, divorce is not allowed. However, if the foreigner will divorce his Filipino wife, then it is allowed by law because the reason the other party is a foreigner. Next, let's go to privileged communication. So when you say privileged communications, these are confidential communications which is barred to be presented in court. Okay, you cannot, for example, classic example, okay, lawyer to client communications are privileged and confidential. So no matter what you do, you cannot compel me as a lawyer to say, okay, or to be a witness against my client. Okay? So, just a matter of reading class. Like what I said earlier, attorney-client privilege communication. There are requisites, okay? Next, physician and clients. There are requisites also. Priest and penitent, okay? Public officers. Okay. Next, parental and filial privilege. So no person may be compelled to testify against his parents, other direct ascendants, children, or other direct descendants. So this provision does not apply to spouses. Okay? So by operation of law class, the following are the privileged communications. Okay? So these are just matters of reading class. Next, let's go to admissions and confessions. So, admission, it is an act, a declaration or omission as to the relevant facts. It may be given by a party, okay, or by a third party. So, when you admit, so, positively, you say in court the facts that it really happened, okay. So, as a general rule, confessions of a defendant made to witnesses are admissible against him but are inadmissible against his co-defendant. However, there are exceptions like confession on the stand, confession not objected to, okay, especially your lawyer did not object to the statement of the witness, then it can be admitted in court, okay. Adopted confession, identical confession, corroborated confession, or confession by conspirator. Okay. However, self-serving declarations, a declaration wherein the testimony is favorable to the declarant, It is made extrajudicially and it is made in participation of litigation. So self-serving declarations are not admissible. Okay, so these are testimonies or statement which will only serve your personal interest. Okay, the personal interest of the declarant or the witness. So as a general rule, they are not admissible. Okay, so again, there are requisites. Okay, differentiation of admission and confession. So by definition, admission is a statement by the accused, direct or implied, of facts pertinent to the issue and tending in connection with proof of other facts to prove his guilt. While in the other hand, confession is acknowledgement in express terms by a party in a criminal case of his guilt of the crime charge. Okay? So, generally, admission are general statements, okay, while confession is actual acknowledgement of guilt. Okay? So, these are just matters of reading, class. Let's discuss these rules governing extrajudicial confessions. Okay, as a general rule, extrajudicial confessions of an accused is binding only upon himself and is not admissible against third party or his co-accused. However, there are exceptions like interlocking confession or if the co-accused impliedly acquiescence or agreed, okay, in or adopted the said confession by not questioning its truthfulness. Okay, where the accused admitted the facts stated by the confessant after being appraised of such confession. Okay, so these are jurisprudence, class. We will be having a case analysis after our theoretical discussion. So these are just matters of reading. Okay. Now, what is res inter alios acta rule? So the rights of a party cannot be prejudiced by an act, declaration, or omission of another. Okay, except in the following instances: by a partner, agent, or other person jointly interested with the party. So this rule, class, implies that a party cannot be prejudiced by the statement or declaration made by other persons or non-party to the case. Okay. However, it has its exception. Like if there is a partner or agent or other person jointly interested with the party, okay, or there is a conspirator or by privis, okay. However, there are requisites also that needs to concur in order for the exception to attach. Okay? So, it's just a matter of reading, class. I will leave this up to you. Now, let's go to hearsay evidence rule. So, a witness can testify only to those facts which he knows of his personal knowledge. Okay, so as a general rule, testimonial evidence must be admitted if it is based on personal knowledge. So if it is not based on personal knowledge, then as a rule, it is a hearsay evidence and must be excluded, okay, in the course of the trial. Okay. Next, independently relevant statement. It is a statement whose probative value is independent of its truth or falsity. The mere fact of its utterance is irrelevant. Okay. So, just a matter of reading. What are the exceptions to the hearsay rule? Okay. The following are the exceptions. Dying declaration. Declaration against the interest, act or declaration against pedigree. Okay. Next is common reputation. Next is part of res geste. Okay. So, this exception class has its requisite that needs to concur, okay, in order for the exception to attach. So, I will leave this up to you, class. Okay. So, furthermore, entries in the course of business, entries in the official records. So, these are exception of the hearsay rule. Okay, commercial list and the like, learned treaty. Okay. Next is the opinion rule. So, the opinion of a witness is not admissible except in the following cases. So, first, on a matter requiring special knowledge. Okay, so if you present an expert witness, then his opinion can be admitted in court. Okay, so take note, guys, class, of the requirements that needs concurrence. Okay, because this is just a rundown class, and we will so that you can appreciate the technical aspect, we will apply it through case law or case analysis, okay, later. Next, rules on character evidence. Okay. Burden of proof and presumptions. So, matters which need not be proved by a party to an action are allegations contained in the complaint or answer immaterial to the issue. Okay, so those allegations which are immaterial need not be challenged because they will not be admitted. Next, facts which are admitted or which are not denied in the answer provided they have been sufficiently alleged. Next, those which are subject of an agreed statement of facts between parties as well as those admitted by the party in the course of the proceeding in the same case. Next, those subject to judicial notice, and then facts which are legally presumed. And then facts peculiarly within the knowledge of the opposite party. Okay, so what are the rules on impeachment of a witness? As a general rule, the party producing a witness is not allowed to impeach his credibility. However, it accepts of exception. First, that the witness is unwilling or a hostile witness. Okay, so here are the requirements also. Okay, these are just matters of reading, class. What is a leading question? It is a question which suggests to the witness the answer which the examining party desires. It is not allowed except on cross-examination, on preliminary matters, and so on and so forth. Okay. Next, misleading question. A misleading question is one of which assumes as true a fact not yet testified to by the witness or contrary to that which he has previously stated. So, misleading questions are not allowed and is objectionable in court. Okay? So, what are the rights of a witness? First, to be protected from irrelevant, improper, or insulting questions and from harsh or insulting demeanor. Okay? So, if you are the lawyer, class, it is incumbent upon you to protect your witness. So, if you feel that your witness is being harassed by the other lawyer, you must make necessary objection. Okay? So, not to be detained longer than the interest of justice require, not to be examined except only as to matters pertinent to the issue, not to give an answer which will tend to subject him to a penalty for an offense unless otherwise provided by law, or not to give an answer which will tend to degrade his reputation unless it be to the very fact at issue or to a fact from which the fact in issue would be presumed. But a witness must answer to the fact of his previous final conviction for an offense. And also, there are exceptions to the rule against repetition of objections. Okay? So, just a matter of reading. Now, let's go to distinction between presumption of innocence and reasonable doubt. So, when you say presumption of innocence, class, this is a constitutional guarantee, okay, that the accused must be presumed innocent until contrary is proven. Okay? So, conclusion drawn by law in favor of its citizen. Evidence introduced by law to be considered by the court. Reasonable doubt. So, condition of mind produced by proof resulting from evidence in the case and then result of insufficient proof. So, when you say in criminal cases class, in order for the accused to be imprisoned, the prosecution must prove his case beyond reasonable doubt that indeed the accused perpetrated the commission of the crime. Okay? So, offer and objection. So, offer of evidence. The court shall consider no evidence which has not been formally offered. The purpose for which the evidence is offered must be specified. Okay? So, when to offer evidence, these are just matters of reading, class. Okay? Objections, just matters of readings. Okay? Tender of excluded evidence. So, weight and sufficiency of evidence. So, what is preponderance of evidence? So, these are evidence necessary in civil cases. Okay? So, in determining where the preponderance or superior weight of evidence on the issue involved lies, the court may consider all the facts and circumstances of the case. So, the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts to which they are testifying, the nature of the facts to which they testify, the probability or improbability of their testimony, their interest or want of interest, and also their personal credibility, so far as the same may legitimately appear upon the trial. The court may also consider the number of witnesses, though the preponderance is not necessarily with greater number. So when you say preponderance of evidence class, it is of higher degree than substantial evidence, but lower degree, okay, as to compared to proof beyond reasonable doubt. Okay? So it is the weight of evidence. Okay? So, in criminal cases, the weight of evidence is the proof beyond reasonable doubt. In civil cases, the weight of evidence is preponderance of evidence. In administrative cases or labor cases, the weight of evidence is substantial evidence. Okay? So, like what I have discussed, substantial evidence, that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. So, as to the weight of evidence, substantial evidence is lighter compared to preponderance of evidence and proof beyond reasonable doubt. Okay? So the last concept is evidence on motion. So when a motion is based on facts not appearing of record, the court may hear the matter on affidavits or depositions presented by respective parties, but the court may direct that matter be heard wholly or partly on oral testimony or deposition. Okay? So, class, this is just an overview of the rules on evidence, okay, of the rules of court. So, this is a technical aspect, and more often than not, it is the lawyer who needs to master this rule. However, police officers such as yourselves must have a working knowledge or an overview of the rules on evidence in order for you to effectively render your service or help the prosecution prove the case or protect the sanctity of the evidence. Okay, so remember class, earlier we have discussed the rule on chain of custody. Okay, so as a rule also, the purpose of the chain of custody rule is the preservation of the integrity of the evidence, so that in court it can be presented and eventually it will help, okay, prove the guilt of the accused. Okay, so class, like what I said earlier, this reviewer is not mine. I only saw this in the internet. However, do not worry, because it is like a bird's eye view of the rules on evidence. By the way, class, the rules of evidence has been amended, but mostly its amendment is useful to the lawyers, okay? Because the lawyers are the one who will present the evidence in court, okay? So, as a collateral responsibility, it is incumbent upon you, police officers, to preserve the integrity of the document or the evidence, so that it can be presented during the course of the trial. Okay, so thank you class, and if you have question, feel free to message me, and God bless us all.